All right. Good day, everyone. And thank you for joining today's Ask Me Anything, where we answer your questions about cannabis legalization in New York. We do this every Wednesday at 4:20 p.m. New York City time. I'd like to welcome back those of you who have joined us before. And for those of you who are joining us for the first time, I hope you'll make it a regular occurrence. My name is Jeffrey Hoffman, and I am an attorney in New York whose legal practice focuses entirely on cannabis. If you would like to contact me, you can do that either here on LinkedIn. I welcome all connection requests, or you're welcome to reach out to me at my email address, which you can see on the screen, info@420jurist.com, which I guess you might say makes me the 420 jurist. And as the 420 jurist, I will be answering your questions, roughly half of them from a list of questions which I've gotten from previous Ask Me Anything sessions, and roughly half from questions which you post in the comments here today. So, if you'd like to ask a question, now is the time to do so. As always, I do have a disclaimer before we get started. Everyone knows attorneys love the disclaimers. And the disclaimer is I am indeed an attorney, but I am not your attorney, at least not yet. Though I do notice there's a few of my clients here in the event today, so folks, don't worry. I am still your attorney. But for the rest of you, I am indeed not your attorney. And today's event is not legal advice. It does not create an attorney-client relationship, and it is not a solicitation to offer legal advice. So, with that disclaimer out of the way, let's get to the questions. And I'm going to start with one that came in during the week, and that is, with conditional dispensaries getting ready to start, does that provide any insight into specifically the 200-foot rule for regular dispensaries? In particular, how will the 200 feet be measured to a place of worship? All right, so that's a great question. For those of you that are familiar with how the alcohol rules work in New York State, as far as the citing of alcohol businesses and schools and places of worship, they are very similar to what have been enacted in MRTA, the law which legalized cannabis here in New York. And in that law, the legislature has determined that the retail cannabis stores, that is the dispensaries and the on-site consumption lounges, must locate themselves at least 500 feet from a school and 200 feet from a house of worship. Now, the question that is being asked is, in particular, what is that going to mean as far as how it's going to get measured? Those of you that might be familiar with the alcohol rules, is it has to do with the establishments being on the same street, and that is particular to the alcohol rule. That language did not appear in MRTA. So, whereas with the alcohol business, basically the alcohol business looking to get licensed and the school or the house of worship get measured only if the two places are on the same street. So, basically, you would come from the entrance of one, go along the street to the other, to the entrance of the other, and that is how you would do your measurement. Might be a little bit more specific than that. I'm not going to get into what the alcohol rules are. It's just simply we want to compare how that will perhaps work related to how the cannabis rules will work. Now, as we mentioned, it is a 500-foot rule for schools and a 200-foot rule for houses of worship. And unfortunately, even though, as we do know, the application will probably be opened for the conditional adult use retail dispensary licenses at some point in August, the Cannabis Control Board, or more specifically the OCM, has to put notice on their website, basically with 2 weeks notice, that from the date of the notice, the application will open in 2 weeks. So Hopefully, we'll see that on their website today. It may even be on there today. I haven't checked their website today. But from whenever they put that notice on the website, the application will be open in 2 weeks. And it is indeed true that all of the conditional adult use retail dispensary licensees, the CATRD, as I like to say, licensees, will have to follow these same rules. They have not been fully fleshed out by the Cannabis Control Board yet. We are still waiting for the initial proposed regulations for the 9 standard licenses, which will be issued here in New York. And any of the CATRD licensees will have to follow any of the rules that are in the regulations for the normal dispensaries. The fact that they are going to be DASNY spaces, although there is a little bit of question about that, and we may talk about that a little later today. And we'll have to measure from those spaces. We do not have any more specificity with exactly how the measurement is going to occur. Is it going to be a walk along the sidewalk measurement similar to the alcohol law? Or is it going to be a as the crow flies measurement where it will not go along the sidewalk, but simply be a straight line measurement between the facilities? Will it be from the property border? Will it be from the entrance of those facilities? Again, none of this information appeared in MRTA, and so therefore we don't know. I do anticipate that we will see information specific to that in the regulations that will be forthcoming. But until we see those regulations, we simply don't know what the answer is going to be. So no, the fact that we're about to start the application process for the conditional dispensaries, the CATRDs, that really does not give us any insight into what is going to happen as far as this measurement requirement. So I know that a lot of dispensary folks that I've talked to are waiting with bated breath to see how that measurement is going to be done. But until we see those initial regulations from the Cannabis Control Board for the standard license, where we will see that how that regulation is going to be measured or how that distance is going to be measured in the regulation, we simply don't know. So keep waiting and keep watching the OCM website, and at some point they will release that regulation for the standard dispensaries, and that will contain the information about the distance measurement. All right, let's go to a question that is hot on everybody's mind, at least on us attorneys' minds today. And that is, do the CATRD licensees need to take a DASNY location? And it does appear we're getting various different responses to that from the OCM and the CCB. It is very clear, despite what has been said elsewhere, that in the regulation that is now official and has been promulgated, that if DASNY or the fund wants you in a space, you must go there. It says very specifically in the regulation that the licensee must sign any agreement and meet the requirements of that agreement from any fund, which goes through, the fund is basically the fund that DASNY is going to use to build the DASNY spaces. So that is applicable. And it does says that they must sign any agreement and agree to any agreement, including but not limited to a lease for one of the space in the DASNY spaces. And again, in one of the facts on the OCM website, it does say that if you are interested in having your own location, that the DASNY spaces are probably not for you. So that seems to indicate to me that all of the DASNY licensees will have to go in the DASNY locations. However, and there's been a great discussion with me and Wei Hugh and a few other lawyers over on LinkedIn. If you want to take a look at that, just look up Wei Hugh's profile, and he doesn't comment nearly as often as I do on LinkedIn, so you'll easily be able to find his comment about this, and we talked about it a bit. Wei and I had a phone call about it. And in the documentation that you can see in the in the OCM websites, there is a place where they review all of the comments that they got for the CATRD license and their response to that. And to one of the comments that said you guys should not require folks to go into the DASNY spaces, it says that these licensees are not necessarily required to go in the DASNY spaces, and they can use other private property that they may have, and that may be viable under this CATRD license. So, very different guidance. I had a person, I think, weigh in the comments with me and Wei that they went to one of the outreach events that the OCM is doing, and they were told at the outreach event that if you're applying for the cat erd license and if you get it, you should plan to be in the DASNY spaces. So from my book, that's 3 pieces of evidence in favor of folks having to be in the DASNY spaces. But again, there is this outlier in their responses to the comments to that proposed regulation, which is now final, where they say, in fact, no, you're not required and you could do private property. So this is a mess. We definitely have different authoritative things saying this. In my back and forth with Wei, he has indicated to me that it's his opinion that the OCM is going to go with you will be able to be in other spaces, not just in the DASNY spaces. I know that Brad over at New York Cannabis Insider has reached out to get the OCM on the record about this issue. So I think let's wait and see what the New York Cannabis Insider publishes from their outreach to the OCM about this. Again, it is very clear to me and other attorneys that the regulation that was approved and is now in effect, which allows the application to open, does make it fairly clear that if DASNY and or the fund want you, well, it does say the fund, but let's be clear, the fund is the fund that DASNY is operating with, so they're all going to work together. But if the fund wants you in a DASNY space, that the regulation is very clear. You have to be in it. It's just this one piece of evidence in the responses to the comments that says otherwise. So clearly we have a conflict here, and I think we really need clarification from the OCM. I do not think they can allow this amount of confusion to be present. So I would, Brad has definitely reached out to them, and I would definitely encourage the OCM to respond and be very clear about this, because they have definitely released some confusing information compared to what is clearly the black letter regulation that they have approved. So be very interesting to see where those things come down. All right, so that's the answer to that question. And there was a follow-on question: if you don't use DASNY spaces, can you access the funding for financing? Again, so this weird response to the comment does seem to indicate you would. That is clearly not how it's looking in the regulation. Even if you're self-funded, as the additional question came in here, the regulation makes it very clear in the black letter of the regulation, if the fund wants you in a DASNY space, you have to be in there. But again, this response to the comment that they posted on the OCM website seems to say something else. So there's clearly confusion here, and hopefully we will get some really some clear guidance from the OCM here, because there is definitely confusion. And if they're going to open up the license here soon, we definitely need extreme clarity on this item. All right, moving on to another question from a previous session. What is the process of obtaining a license to sell in New York? Also, can you grow pot cannabis in the Carolinas and supply it to New York? So for the first part of the question, the answer is that the process is exactly what a lot of my clients are working on now with me. You need to review what the application is going to look like for the cat erd license. We do know exactly what the application is going to look like. So you need to make sure you have your ducks in a row to answer the application. You need to make sure that you have your ducks in a row as far as the other service providers you'll need, such as an attorney, an accountant, maybe a real estate person if you're going to get on-site dispensary, on-site consumption lounge or a dispensary. You need to be thinking about what is your product mix is going to be. You need to be creating your business plan. It is not an initial part, it doesn't look like, of the cat erd license, but for the follow-on licenses, you'll need to come up with your sustainability plan, your plan about how you're going to assist communities disproportionately impacted by cannabis, and just all of the other types of things that you may need to have to apply for a license in New York. We will know much more about that when the CCB releases the draft regulations for each of these licenses. I think within that, you will also see their draft proposed application. So that's what you need to do to proceed through the process to apply for a license and attempt to get one. Something that you also want to make sure is true for you and anyone you're going to list on the application. You want to do a background check. You want to make sure nobody's got any unpaid taxes or no filings for taxes. You want to make sure that there are no outstanding warrants, that you don't have any child support, any other types of things that can ding you. So just really make sure that your record, and anyone that you're going to list on the application, that your record is clean and that you've got no outstanding fines or payments. Just want to be clean as possible when you apply for that application. Now, on to the second question. Our second part of the question, can you grow pot in the Carolinas and supply it to New York? Well, so first of all, if you were growing full THC adult use cannabis in the Carolinas, I think you're going to get arrested because the Carolinas have not legalized cannabis yet. They've only legalized hemp. There is a bill in the legislature for North Carolina, I believe. Well, I'm certain because I've read it and I'm talking with several folks in North Carolina about that. That just happens to be one of the other states that I'm licensed in. So to grow adult use cannabis would have to be legal in the Carolinas, which it is not. So the premise of the question is just a little off. Let's substitute Massachusetts for the Carolinas. And no, you would not be able to grow cannabis in Massachusetts and then supply it to New York. Currently, the MRTA, the law here in New York, says that all of the cannabis that is going to end up in retail dispensaries or in on-site consumption lounges or getting delivered by the delivery licensees, all of that cannabis must be grown and processed here in the state of New York. That is a state law. We can argue about interstate commerce clause all you want, but we don't even have to do that because state law here in New York says all of the cannabis in the adult use cannabis industry must have been grown and processed and distributed here in the state of New York. So you can't grow it in the Carolinas. Although, like I said, I think your bigger problem is going to be getting arrested in the Carolinas for doing that. But you could also not grow it in a state that has legalized the growing of adult use cannabis, and you could not bring that into New York. That is against the law according to MRTA. So don't do it. All right, let's see what other good questions we have here today. Can you share any insight about on-site consumption lounges? So we can share a little bit of insight. They do fall under the 500-foot rule and the 200-foot rule that we discussed earlier on today's call. Can't be within 500 feet of a school or 200 feet of a house of worship. The on-site consumption lounges are going to have to notify an entity that is in the locality where you wish to open the on-site consumption lounge. Here in New York City, that entity is going to be the community board in each region in New York City. I live on the Upper West Side of Manhattan, and for us, the community board is Community Board 7. And clients of mine that are going to look to apply for either of those licenses will have to appear before the community board and present their plan and what they're looking to do. This is very similar, almost exactly similar, in fact, exactly similar to what you would have to do to apply for a liquor license here in New York. You have to go in front of the community board where you are going to locate the business and present to them your business plan. Now, that community board does not have a up and down vote about your license. What they do, much like with the liquor license, is they will put in a letter to the Cannabis Control Board with your application, letting the Cannabis Control Board know what they think about your application and whether or not they approve of you getting it. Again, that is not dispositive. It is completely up to Tremaine Wright and the Cannabis Control Board to decide whether or not you get your license. Now, I've seen Ms. Wright speak about this matter a number of times, and she has made it very clear that in order for the CCB to not approve your license application as per whatever they get from the community board or whatever the entity will be in other jurisdictions not in New York City, it's not good enough for you to simply say, we don't want a cannabis dispensary or a cannabis on-site consumption lounge in our community board. If that is the only reason that the community board gives for being opposed to your application, then Tremaine Wright is going to get out her big approved stamp and stamp your application approved, at least as far as what the community board has to say. Legitimate reasons for the community board to be opposed to your application are things such as the applicant also owns a bar in the neighborhood and they never close their garden at the right time. They always have people in the garden way past the curfew for people being in outdoor spaces for bars in New York City. They always get noise complaints at the bar. They've got 100 noise complaints at 311, which is the way we report noise complaints here in New York City. They've got many outstanding violations with the state liquor authority. They've got violations with the tax authority related to the filing of their taxes. So those are legitimate reasons for the board, the community board, being opposed to a dispensary or on-site consumption lounge application, and those would be reasons that the Cannabis Control Board would definitely take into consideration as to whether or not they should not approve your license. Several other things: you won't be able to have alcohol served at these locations. You won't be able to have simulation at these locations. And what simulation is in New York, it's effectively what happens at strip clubs. So those types of activities will not be able to happen at cannabis control boards. There's a few other things in MRTA related to the cannabis, what the on-site consumption lounges will or won't be able to do. I'm not going to go into all of them. Would encourage you just to get your copy of MRTA and take a look at it. It's very specific there in the section about, there's two sections actually about on-site consumption lounges where they talk about this. Just go look at those sections and you'll see everything that we know at this point. We obviously will get a tremendous amount more information from the Cannabis Control Board once they release the regulations. Hopefully those are coming soon. Your guess is as good as mine. But that gives you some insight into what we know at this point about on-site consumption lounges. Thank you for the question. All right, we're going to do a few more here. Let's go to another one I got previously, and that is, will you apply for the now vacant attorney position? For those of you who may not know, the general counsel of the Office of Cannabis Management resigned without very much notice very recently, and it's really just very interesting that is happening now as we're starting to get knee deep in the licensing. It's not ever good when someone like that's that important to what we're going to be doing here resigns like that. So not good. So they do need to get another general counsel in there quickly. But as far as whether or not I'm applying for that now vacant position, if nominated, I will not run. And if elected, I will not serve. I do think that it's a fairly thankless job being the general counsel of the OCM. Nothing you're going to do in that position is going to be right. Everybody is going to be yelling and screaming at you about the way you interpret the law and the things you want to do, and just nobody's going to be happy. You're going to be Samson splitting the baby on every single thing that you do. And I just, they need someone. They need someone very good. They need someone that really understands cannabis issues. And I get that, and I appreciate the fact that a lot of folks think that I might be qualified for that. I'm having a lot of fun what I'm doing, having clients work in the cannabis industry, and I simply couldn't do that if I was the OCM's general counsel. I'm working on a lot of cannabis justice and employment issues for communities that were disproportionately impacted by cannabis enforcement. Probably couldn't do a lot of those things if I was the GC over at the OCM. I think that's probably a 28-hour-a-day job. And, for all the reasons above, thank you for thinking that I might be qualified, but it's just not something I'm going to do. All right, let's do one or two more questions, and that'll then be a wrap for the day. So let's see what else we're going to do here. When will the micro license app be released? It's a very good question. The open question I think we have about the 9 standard licenses here in New York is, are they going to release the regulations all at one time, or are they going to release them piecemeal like we have seen for the conditional regulations? I think, as you've seen, conditional came out first. Well, let's be clear. We didn't really need a regulation for the conditional. It was a law passed by the legislature, and the OCM just very quickly made some things clear about it and got that application up. Something very similar happened with the conditional processing license. No regulatory review period was necessary. So the OCM was just able to say a few things about it and get that application up. They're currently taking applications for that license. And then for the cat-erd license, the one that everyone is very interested in, the contradicting information we've been getting about it recently. But for that one, obviously, we did have to go through a regulatory review process. They chose not to go through the second half of the process. They ignored all of the comments, although they did give us a lot of responses, which you can now go and look at on their website. So we're getting ready to have the application for that. But for these other 9 licenses that we're waiting on, we're going to have to go through the same regulatory review process. So the sooner they release it, the better. But it is entirely possible they will release those 9 standard licenses in a staggered fashion. So we may see the cultivation license first, and they do some things with that, and then we see the processing after that, and then they work their way through. I've seen a lot of people speculating that the micro license will be the very last one to be released. I think that's an interesting speculation. As we like to say, they're speculating on a hypothesis. I don't know that I think that'll necessarily be the last one to be released. I do think it's entirely possible that they will stagger the release of the regulations. But I've not seen anything that makes me think 100% that for some reason the micro license one is going to be last in line. So we hope that these regulations are released very soon. We really need them. It would be great to start that application process before the end of the year. And if they want to do that, I think they really need to get cooking on the process. But we absolutely do not have a definitive date yet as to when the micro license one will be opened. And we'll just have to keep our eyes on the OCM website and their press releases as to when they're going to release that initial regulation. Another question from today. How difficult is it to obtain a nursery license? And I think it'll be relatively as difficult as any of the other licenses. I don't think a lot of people are going to apply for that license. I think you'll see a lot of cultivators apply for that license. The cultivators are able to apply for that license. It's one of the places in MRTA that is an exception to the rule about being able to only have one license. A cultivator definitely can have their normal cultivation license and one nursery license. I've talked to various folks that are interested in just getting the nursery license. The nursery license is one of the licenses that is to be specifically promoted to social and economic equity applicants. So if you are a social and economic equity applicant, if you have a green thumb or have operated a nursery or perhaps worked at Lowe's or any of the stores that have garden departments, I think you would be an excellent candidate to open a nursery. There's a lot here in New York City. There are many stores that are plant and flower stores. They help individuals that are lucky enough to have balconies or folks that want plants in their homes to kind of curate their plants that they're going to have in their homes. I think those people that run those stores would be outstanding applicants for the nursery license. So we'll just have to see what happens here in New York as far as who's going to come out of the woodwork to apply for that license. Again, I do think you will see fewer people apply for that license, so perhaps that will give you a better shot at getting the license. Much like all of the other licenses, if you show you have a coherent business plan to do the thing you're looking to do if you have proof of having done that thing in the past, I think that's super beneficial. And if you show you have the capital to be able to open a facility that does these things. If you have all of the above, I think most anyone is going to be a great applicant for that license. And again, since it is one of the licenses that is to be specifically promoted to social and economic equity applicants, I would encourage a lot of social and economic equity applicants that have gardening experience to apply for this, because you are who the license is to be targeted to. All right, we've only got a minute left, so I think we're going to call that it for today. I want to thank everyone for participating in today's event. Those of you that merely attended and those of you that submitted questions. We do it again next Wednesday at 4:20. We do it every Wednesday at 4:20. So we'd welcome everyone here to participate next week. Again, if you're not currently a connection of mine on LinkedIn, please send me a connection request. I welcome all connection requests, but especially from folks in the cannabis industry. And as I say every week, I know everyone is very excited that we're about to have a regulated cannabis industry here in New York, as opposed to the legacy cannabis industry that we've had for my entire lifetime. And while that is very exciting, the most important thing that happened in the law that passed is that now everybody with low-level cannabis convictions is getting their convictions automatically expunged. Those with higher level cannabis convictions can do a 440 motion in the court where they were convicted to attempt to get it expunged. And we just have to make sure here in New York that we've got all of the non-violent cannabis offenders out of jail. I know there are still several of them in New Jersey. And literally just last week, we were able to get the JOC modified for one of them, Mr. Humberto Ramirez, if you may be familiar with his case. And now we're just waiting for the folks at parole to punch a few keys on their keyboard and go see Mr. Ramirez, and then he's out. So hallelujah for that. I would encourage, if anybody knows folks in the parole board over in New Jersey, I've been pinging them daily. Please go visit Mr. Ramirez and let's get him out. So if you know people on the parole board or in parole facilities in New Jersey, I'd encourage you to reach out and say, please go visit Mr. Ramirez and let's get him out. He's ready to roll. And that is the most important thing that we're doing in New York, getting everybody's convictions expunged and making sure everybody is out of jail. So let's do it. I'm very involved in that, and you're going to hear more about that in the coming weeks and months. Thank you, everyone. Thank you for participating, and have a great afternoon and a great week until we see you next week. Have a good one.